present in the courtroom, please rise. The Court of Appeals is now in session. Please be seated.
Good morning and welcome to the Court of Appeals today. Counsel, you can come forward and be seated at the tables.
Your Honor, may my client sit at the table as well?
Absolutely. We are here this morning to hear arguments in the case of McPherson v. Copp. On the panel today, I am Judge Michelle Christensen Forrester, and I'm joined on the panel today by Judges Greg Orm and Judge Dave Mortensen. Counsel, if you could please enter your appearances for the record.
Good morning, Your Honor. Ledger Thompson appearing on behalf of the appellant, Lynn Copp, who's present.
Good morning, Your Honors. Brody Miles on behalf of the appellee, Mr. Sean McPherson.
Thank you. Both sides have 15 minutes in which to make their arguments today. I don't know that I've seen either of you in court before, and if this is your first time arguing, great. If not, welcome back. And it looks like, Ms. Thompson, you've reserved 3 minutes for rebuttal.
Correct, Your Honor. Thank you.
We will try and keep to the time. We're a little bit more strict with our timekeeping, but then, you know, another court that's across the hall. But if we're asking questions, feel free to take whatever time you need to answer them. And don't be worried about the clock or cut yourself off if you're answering questions from the court. Do either of you have any questions about how we will proceed today?
No, Your Honor.
No, Your Honor.
Right, then if you're ready, Ms. Thompson, please. And if you could enter your appearance every time you take the podium, that helps for the recorded, the record that we're keeping.
This is my first time appearing before the Court of Appeals in Utah, so may it please the court, my name is Ledger Thompson. I represent the appellant, Lynn Copp, in this matter. We filed an appeal on 3 issues, and I'd like to first focus on the issue of uniform and general reputation as husband and wife, the last element in the common law marriage analysis. As the court is well aware, in family law cases, these are highly fact-specific cases, and in common law marriage cases, they're even more so. They're more heavily reliant on facts. And in this particular case, the court must look at the totality of the circumstance of this family, because this is a family that started in Breckenridge, Colorado. They had multiple moves, and their moves were not small moves where people maybe size up and home in the same neighborhood. This is a family that moved from Breckenridge to Denver, from Denver to Salt Lake or to Sandy, Utah, from Sandy, Utah to Mexico, crossing the border, from Mexico back into Salt Lake City, and from Salt Lake City up to Park City. So those were 5 moves over the course of 7 years, and 5 substantial moves. And so in looking at whether or not they held themselves out as and having acquired a uniform and general reputation of husband and wife.
Can I interrupt you just to make
Yes.
sure we're on the same page? The conclusion that you're challenging isn't that the trial court concluded that they didn't have categorically this reputation. The conclusion of the trial court was that there was a divided reputation. And that is the finding that you're attacking, right?
That's correct.
That under the evidence, you're saying that it is clear error. I know your briefs talk about abuse of discretion, but this is a factual finding, so it's reviewed for clear error, that it's a clear error to conclude that it's a divided reputation.
Correct, and if you look at Volk v. Vecchi is really the controlling case law in this matter, and that's what the lower court relied on in its final findings. But in the findings, the lower court, and I want to get this correct, the lower court talked about A partial and divided reputation of marriage may be shown when the party's closest friends do not consider the parties married. So the court relied on that section from Volk v. Vecchi, but then Mr. McPherson's 31 witnesses were not my client's closest friends. They were his closest friends. They were his work colleagues. They were his college friends, high school friends, and family members.
So
the-
you read Volk versus Vecchi as establishing that only closest friends are relevant for that determination?
Well, that's what the lower court relied on. The lower court pulled that passage
I'm
from
not asking
the
about the
Volk.
lower court. Are you saying that that this court, our court, established that as a limited standard that only the closest friends are relevant?
No, Your Honor. I think by definition of reputation, reputation sort of presupposes that you're talking about a collective or a community. And it's our position that the only collective or community that was presented was this Waldorf community. This was a family, both parties were very dedicated to their child.
Additional question on this. Would you agree that if we disagreed with you on this point, that we thought the trial court's finding of divided reputation was sustainable? I understand you disagree with that, but if we found that it was sustainable, do you agree that that would be sufficient to affirm? In other words, we don't need to get to this issue of consent, whether that's the right standard or not, since the statute for common law marriage requires these elements. If the court had this finding that we sustained, do we need to get to this issue of consent? Do you understand my question?
I think we still need to get to the issue of consent, but maybe the court can rephrase the question.
Well, often we'll have either a statute or something that has multiple factors, and in order to prevail, you need to show all the factors, and if you fail to show one, depending on the factor, that could be dispositive of the whole case. So if we were to decide that the finding of divided reputation was at least within the realm of what the court could find on the record, even if we disagreed with it, we still give the trial court's deference. So that, we're gonna deny your appeal as it, I'm not saying we're gonna do this, I'm just saying for this hypothetical, we're gonna deny your appeal on the issue of a divided reputation. Why must we then move on to this issue of consent?
The case law is clear that all of the 5 elements of common law marriage have to be established in order to find.
That's exactly what I'm asking.
Yeah,
So if we found that one was missing, it doesn't matter on the others, right?
It doesn't. If one was missing, you're correct, then it does not matter.
I'm hogging up. Does anybody else have a question? Because I have another question.
You go for it. I
Okay.
have a question, but I'll follow up after.
Volk versus Vecchi, you just said it's controlling law. Is that right?
Well, it really is the most recent case and
I'm
one
not
that-
disagreeing with
Well,
you.
it's one that's heavily relied on in the
And
common
your
law
brief
marriage.
doesn't ask us to overrule it, right?
We are not asking to.
Okay. Nevertheless, I will tell you that your analysis of the statutory amendment and whether this issue of consent survived the amendment is an intriguing one.
It is.
And arguably maybe the Volk versus Vecchi court got it wrong, maybe.
Maybe.
But you haven't asked us to overrule it. Do you see the quandary that puts us in? So Volk versus Vecchi expressly says, citing Hansen and White, which you point out are from before the amendment, but it says it survives and we have to have this issue of consent. Where you're not asking us to overrule Volk versus Vecchi, what do we do with that now at that
Well,
point?
I think if you look at the dialogue in the Volk v. Vecchi appeal, they really talk about acquiescence, right? The facts establish an acquiescence of consent. And I think that's what that court did, and that's what we have here. We have joint filing as married joint filing of taxes. We have applications of housing in Park City and in Salt Lake as a married couple. And those witnesses testified that they believed they were married because that's how they filled out the application. You have references by both parties to each other as husband and wife. Mr. McPherson disputes that, but we presented evidence that there were references. You have a family that's moving across country and international lines to support Mr. McPherson's career, which is exactly what happened.
But to be fair, your brief is saying, and this is a legal issue, not one of these clear error issues. You're saying that the trial court's reference to this thing arising between two consenting adults was an erroneous standard. And my problem that I'm choking on, to tell you the truth, is that Folk versus Vecchi says that's the standard. So how is, if the trial court has to follow Folk versus Vecchi, how is the trial court in error in focusing on those two consenting adults phrase? How can we find that? What I'm saying is I understand your argument. I may be convinced that Folk versus Vecchi, as to that reference, the end of paragraph 12, is wrong. But I haven't been asked, we haven't been asked, there hasn't been an Eldridge, State versus Eldridge analysis to ask us to overrule that precedent. So now I'm stuck, or we're stuck. We have to apply this. How can we find that the trial court is in error if this is the precedent that bounds the trial court? Do you understand that?
I do, but I would ask the court to just look at the statute. The statute is very clear. The statute changed, took out that statement about consenting.
I get that, and I may even agree with you.
Right, so I would just ask to look at just statutory construction supports our position that you don't need to find consenting adults because they specifically removed that from the statute.
So I think
So
what
if
you're
the-
asking, sorry.
You could be, it seems to me, arguing that the statutory amendment, in effect, overruled that, any aspect of Folk versus Vecchi that is inconsistent with the statute is amended.
And that is what we're arguing, that you, looking at the,
Except Folk versus Vecchi came 16 years after the amendment. And quotes the statutory language as it currently exists and purports to be construing the statute as it currently exists.
As amended.
As amended,
as amended.
perhaps wrongly, but what do we do with that?
We are asking the court to reverse because the statutory language does not state that that's a requirement.
So you are in fact asking us to overrule Folk versus Vecchi in that little piece?
In that little piece, yes. I think Volk versus Vecchi in our application really has to do with reputation. And our position is that the spheres, and that's the term that was used in the argument of Volk versus Vecchi, is the spheres of Mr. McPherson were not Ms. Copp's spheres. The only overlapping area that they had really was this school, the Waldorf community. This is the school that when they actually looked at the Waldorf community when they were in Colorado, and that was what they focused on. And then when they moved to Salt Lake, they focused on the Waldorf community and quickly enrolled their son, who was a toddler then, into the preschool. And then they moved to Mexico, came back, re-enrolled the child into that Waldorf community. That really is the only community which, by definition, as we point out in our brief, which is how you get to reputation. You need reputation within a community. The witnesses presented by Mr. McPherson were not in my client's community, but both clients participated in the Waldorf community. And keep in mind, and that's why I'm asking about the totality of the circumstance, that this was a family that moved quite a bit. This is a mom that was raising a young child, and both she and the young child had health issues. So it is not a far leap that they wouldn't necessarily have a lot of communities that overlapped. He certainly had his communities, but the only overlapping community was the community of the child's school. That is where both parents participated. They interacted with parents, they interacted with school staff. The child had friends there, and that's the community that should have been referenced as having a partial or a reputation as husband and wife.
But we have, I mean, if you think about your own life, if I think about my own life, I have lots of communities, lots of different communities. And why would one community be more important than another community?
And I don't think it's not, I'm not asking the court to view it that way. I'm asking the court because of their circumstance, where they really did move quite a bit and move substantially. This was the only common community that they had. So even if you have your own communities, this was one that they both participated in. So witnesses that could testify to that community really are the ones that have personal knowledge about whether or not they held themselves out as husband and wife.
But the trial court discounted, to a certain extent, discounted the reputation that came from the Waldorf school community, because many of those witnesses, and one specifically, I think Ms. Christofferson, testified that we just assume that parents who have a child in common and who attend the school are married. Aren't you asking us to sort of apply a presumption that people who are together and participate in a community, I mean, the witnesses sort of applied this presumption that, or assumption that people who are together are married.
Well,
How do we deal with that? And the trial court's sort of discounting of that?
I mean, I think it really goes again to the totality. The witnesses from the school also knew them before they moved to Mexico and after they moved to Mexico. So I believe one of our witnesses said, boy, they moved across international lines. So knowing that, then they present themselves at school. They're very involved in the child's school. They live together. Witnesses testified that they referenced each other as husband and wife on occasion. And so if you look at all of that, then that supports the reputation within that community. So I think in this particular case, given these facts, it is difficult because they've just moved so much during that 7-year period of time. I'm out of time, but I want to
I have
make sure.
one question.
Yes.
I recognize that Volk versus Vecchi has this reference to a collective perception or estimation by the public or a community. But if I look at the plain language of the statute, it speaks in terms of a uniform and general reputation as husband and wife, which seems like it would be not community specific, but encompassing all the relevant communities. For it to be a general and uniform one, it should have been the reputation in Breckenridge, in Denver, in Mexico, in Sandy, Salt Lake, Park City, the school community, the local community. Now, the tax filings and housing applications and so forth are consistent with that. But the language of the statute itself almost seems to cut against drilling down to just a community here or there by speaking in terms of a uniform and general reputation. What do you think about that?
Well, I mean, I think reputation, as we defined, includes a community. And again, I realize that they had multiple, well, his witnesses did deal with his community, his solar community, his college community, his friend community, I think his community from California. His witnesses dealt with that. But the issue, again, really goes to the facts of this case, because she was ill. I mean, she was ill, and their son was ill, and she was home raising their son, supporting his career. So it is difficult to have all these other communities when she's dealing with personal issues and raising a small child, and they're moving so significantly. So that's why our position is the only community that the court should look at in this case really must be the community of the school, because that's the only community that was consistent throughout. And the court talks about, Breckenridge to Denver. Well, they were part of the Waldorf community, or trying to be part of that Waldorf community even when they were in Colorado. And then they continued it in Utah and returned back to it when they returned back to Utah after leaving the country. So I think, again, these are highly fact-specific cases, But to rely on witnesses that really didn't know my client, I mean, many of them hadn't even met her, and some only met her once or twice, does not comport with what the statute is requiring.
Sorry, can I ask one more?
Of course you can.
Jumping to this issue of the witnesses that were not allowed. There was reference to the RJW media case. And in your brief, you say we shouldn't look at that case because that's a case having to do with expert designations and not normal fact witnesses. And I just wanted to give you a chance to respond in Johansson versus Johansson, authored by Judge Orm. It says that RJW media dealt with disclosures about expert testimony, while RJW media dealt with disclosures about expert testimony, these policy considerations apply to all disclosures and to the circumstances of the instant case, which were more fact witnesses. So I think that the RJW analysis has now been expanded to any disclosures. Do you have any reason we shouldn't view it that way?
I mean, this was back in 2020, and, you know, there was, no, to answer your question, but I think in this court, the court had discretion. We could have had a continuance. I mean, this was very fact reliant. We had substantial witnesses that we felt were timely disclosed. They were disclosed well in advance of trial. Ample evidence because they were narrowed facts witnesses to get depositions done. We had depositions already scheduled on other witnesses. So the remedy we asked for was a continuance because it was so critical to the case. But we're also submitting that, you know, this is quality over quantity. We believe that the quality of our witnesses demonstrate that reputation within the community.
All right, and I just want to be clear on the record. It's more a statement than a question. I didn't mean to throw any colleagues under the bus on Folk versus Vecchi. It also, to be fair, doesn't appear that this issue of consent was teed up by the parties in that appeal. So it doesn't surprise me that made its way in there. I don't want this recording to get to the ears of anybody on that panel that I was casting aspersions.
Thank you, Your Honor.
Thank you. Mr. Miles.
Thank you, Your Honors. Brody Miles on behalf of the appellee, Mr. Sean McPherson. I guess to first address one of the early questions is that they are all necessary requirements, each of the subparts. And I know that Judge Mortensen was the author of the Rivet case, which happened kind of simultaneously with the Volk v. Vecchi case that came out just a couple months later. Now, the Rivet case, I thought it was interesting in paragraph 9 of that opinion. It identifies 6 elements needing to be required, and that was kind of citing to the language that went back to the White case, kind of suggesting that we have the 5 sub-elements of the A, B, C, D, E.
So I did the same thing that Volk did.
It's the same, but the approach has been consistent. And that's because I don't think that the legislative history or the change in the statute necessarily removes consent. And I know we kind of went over that quite a bit in the brief, but I don't know how subpart A could be a relevant criteria, capacity for consent, if consent itself was not also a requirement.
I can. I think that line in the statute talking about capacity to consent wants to remove, and we have one case where we said this is easy, this can't be a common law marriage because one of the parties was married at the time. And so a person who's already married does not have the capacity to be married. Or, let's take another one, somebody who's a minor and their parents aren't consenting, although I think that's even been amended now that that's not a thing anymore, but, or at least not to the early age we used to allow. But they don't have the capacity to be married. So I think that element's looking at legal capacity to be married. I suppose the other elements are going to specific issues that are reflective of implied consent. I think that's what common law marriage is talking about, is we're gonna, aren't we? Aren't those, you
I
know,
mean,
hold yourself out, so
yes.
we're implicitly.
That's correct. I mean, I believe Judge Orm authored the Hansen opinion that came out and kind of said, hey, here are all the criteria that we look at for implied. There's also suggestions that it could be in a written form, right? The parties could execute a document that expressly does that.
Right.
But what that rarely ever occurs, and so we're usually looking at what are the implied actions of the parties. And that's kind of consistently used in all of the cases thereafter and long after that 2004 amendment occurs. I mean, we also point out that the language itself says that it requires a contract between a man and a woman. That's the new language that occurs. And we broke down what a contract, if we're looking at plain statutory interpretation, we would also need to look at, well, what does a contract mean? And you know, we kind of delved into some of the contractual language, but generally it's offer and acceptance. It is mutual, there's mutual consent, and this is where we cite the Golden Realty case, and as well as the Clark v. Jennings case, where they identify that there's mutual consent on material issues. And that's also in the Volt case, when you look at paragraph 27, one of the things that they wanted to make sure is that, as explained by our courts, parties to a common law marriage must consent to the rights and responsibilities that accompany a legally recognized marital relationship. This is why we have that consent aspect of it, is because they don't want parties to just accidentally run into a marital obligations and those things that would occur if a marriage were to be enacted. And so I believe with those facts, with the contractual language and the way that the courts have routinely found that to be the case, I believe that the change in the language, I believe it was potentially even removing a redundancy, because if there's a contract, there must necessarily be consenting parties.
Well, I kind of wonder about that. Maybe this is another way of stating Judge Mortenson's concern. If you take out the requirement of actual consent, it may be that the legislature adjudged that you can't be playing games here and trying to have it both ways. You can't among yourselves says, oh, amongst the couple. One can't say to the other, FYI, I am not consenting to a common law marriage. But then you go on about your business, filing joint tax returns as though you were holding yourselves out as husband and wife, cohabiting, all the harm, assuming marital rights, duties, and obligations, and then just on the side say, I don't consent to this. The legislature is basically saying, no, you can't play that game. If you're going to be doing all these other things and holding yourself out as husband and wife, never mind the consent. I mean, that's the only logical way that you could leave in the requirement of capable of giving consent. Judge Mortenson gives good examples of why that could still be a very germane consideration. But the actual consent requirement falls by the wayside. It's not exactly a contractual thing. It's a perception, reputation, holding out kind of a thing.
Sure. The only thing I would know with the contractual component of that, and because it has an interplay with section of the divorce code of 30-3-1, because currently as written by the legislature, a divorce is predicated on a marriage contract. And so this contract here, I mean, a contract can be established either explicitly through writing, right, or through what Your Honor says is a series of actions that would indicate that there is that. And that's why that entire illustrative list that starts in Hansen and goes through each of the cases thereafter say, here's the things we can look at. I know you keep saying the tax returns, but we have, you know, did the parties ever have joint bank accounts? Did the parties ever have joint property together, joint debts? And these are all things that the trial court went through and did an entire illustrative list saying the preponderance of the evidence indicates that there was not consent. He acknowledged, hey, there was, 3 years of the 9 that they had a relationship, that there were joint tax returns, but there was also a domestic partnership filing. You know, why would there be a domestic partnership if you guys are saying that you're married? You know, that would undermine the idea of consent. And so I don't think it would get rid of that. I mean, you could think of other examples on consent where, you have an underage, that was kind of briefly brought up. There could be a a person getting injured in an accident, and that, I think it could apply to a whole lot of situations, which I'll get into when we get into the communities, is Your Honor kind of pointed out on the community issue, here they want it to be one particular community, but if you're saying like, hey, the law is, it's the school community, because that's almost effectively what they're asking is, we want it to be the school community, that's what we want the law to be. But if two people don't have kids, that's not something that's gonna be applicable. If you have two adults with no children, and let's say they live on a ranch, it can't be the immediate neighbors at that point, so it can't be it has to be what the Rivet Court says, which is how do they show themselves to the rest of the world? And so I think there's.
And that both is, I mean, it has to be both individually and as a couple, right?
I mean, I think that it can be both on that. I mean, you can just imagine the plethora of experiences in like our interpersonal relationships that we have with people. There are some people that never meet a person, even though they might be my best friend, they might not have interactions, and they can still have knowledge. It wouldn't be a hearsay issue because it's just what they're understanding of. I mean, one of the issues that I have, again, they're kind of attacking that the judge did it wrong, but I also feel like the findings need to be found to be clearly erroneous. And at the trial court, and we kind of brought this up, is that there's a lack of preservation towards how witnesses provided testimony. So the court received testimony that was uncontroverted, so that's unchallenged testimony. And then the only thing that the court now looks at is, okay, we have these findings. You need to show me that they're against the weight of the evidence, or that they're completely wrong, and they can't do that because they weren't. And then the application of it. Oh, yes, sure.
I just wanted a clarification on the record. There was a trial here.
There was a trial.
There were declarations that were filed
That's
prior to the trial, but there was cross-examination and examination of the witnesses.
That's correct.
At trial.
So at the trial, the pretrial order, the parties agreed, given the amount of witnesses that were submitted, that they would be submitted via affidavit, and subject to having the witness review it at the trial and then proceed with cross-examination. Anything that there were issues with the affidavit were to be objected to. I kind of laid out a little bit of the process in the brief, and then which would give the party the ability to provide foundation if there was an objection, as you would normally have in a trial setting. And there was never an objection about foundation for any of these witnesses. The only objection that came up that we cited in the record was if a witness tried to opine about general reputation for communities, because they said, hey, that's beyond yours. The judge is going to take all of your respective ones and figure out what to make of that reputation in accordance with the Rivet and the Volk cases. So that was kind of the procedure that was laid out, and so there was ample opportunity to say, hey, here's the cross-examination. There was limited cross-examination. Some witnesses had more, but in the briefing, they don't show where there's contradictions to these pieces of evidence. Like, for example, one of the primary people that he relied on was John Good, who they had dinner together in 2016, and there was a question about their relationship status, and they said that they weren't married and that they weren't intending on getting married, and this was in 2016. It was, again, it's an unchallenged finding. And they need to show how there would be an abuse of discretion as to these findings to the interpretation of the law, and ultimately, the court, I think, correctly came down on the issue of saying it's a partial at best, which is as outlined in the Rivet case. You look at the people and the rest of the world. That's kind of the big thing I think is getting lost. Is we want to focus it. She wants to narrow it on one thing that helps her client. But the noticeable thing about all of her witnesses is, and we point this out in the briefing, is none of them have a relationship with Mr. McPherson. In their testimonies, none of them had met him more than a couple times. She had no witness, I think, that went over 4 times in their interactions, and most of them, like, for example, her mother was a primary witness. She'd met them there was 4 times over the course of their relationship. Her brother, it's been 2 times. He lives in Illinois. She attacks his witnesses saying they don't know the parties together, but all of her witnesses were the same way, and that's what their testimonies reflected, and that was how it came out in cross-examination. So even her attack of the court's use of these witnesses would undermine her very own argument for this, because they weren't good friends with both of the parties.
Well, most
Other than
family
the
members are not members of the Waldorf school community.
Correct, and family members aren't, right? Because I mean, and it kind of goes back to the Hansen case where there's a series of cases that they cite to. And I thought that was helpful because it's kind of where we were laying the groundwork for these principles, because it was kind of more of a novel issue at that time. And in the Hansen case, it incorporates the Colorado case, the Pennsylvania case, and I think the notable ones is that it specifically goes out of its way to say that it should not be limited to a couple people in the neighborhood. Like, that, it went out of its way to say that. More so saying we want acquaintances, friends, family. We want kind of the kind of a holistic approach of what is the general community, because it goes back to that general and uniform, reputation. And here the court found, hey, we have about 36 witnesses from all walks of life, and that it stemmed from the beginning throughout the relationship, that said we know that they're not married. They never referred to each other as husband and wife. We didn't see her wearing a wedding ring. She didn't take his last name. And they ran the gamut, saying, some say that they would hear boyfriend or girlfriend. And they all undermined the idea that there was a reputation as to the parties being husband and wife. And there can also be some conflating between what consent is as well as reputation. So, for example, Your Honor brought up the joint tax returns. That typically is weighed more in the context of consent, because when you're dealing with third-party institutions, they look at that as more of a consent issue rather than how you're holding yourselves out to other people. And the court ultimately said, given all of the witnesses that we have, at best I can find is a partial and divided one. And I think that should be upheld. As it relates to the discovery issue, the Johansson case really hit this issue, and I think it's exactly what happened. Is there was a disclosure of 23 witnesses for the first time on the last day of discovery, no contact information. The 9 that, or I guess the 8, if we were including Ms. Copp, the other 8 never had their contact information, but Judge Mrazek said, hey, because they submitted affidavits as part of a summary judgment, I'm going to allow it. You could have followed up, you could have done something. But the 23 came in on the last day. There was no time for discovery. We were 14 weeks out from trial. She mentions a deposition, but it was only for unavailable witnesses for trial. It wasn't a discovery deposition. It was witness can't be there, and so we need to conduct this because they're not going to be available. And that they haven't shown that the discovery would have actually helped their case. We have no idea what these witnesses were going to say. And I see my time's out, Your Honor. Do Your Honors have any questions?
It does appear not. Thank you, Mr. Miles. Ms. Thompson?
Thank you, Your Honors. I really want to conclude with sort of the legislative intent of the common law marriage statute, and that is to avoid precisely what we have before this court. This is a couple, a family, where my client supported his career from 2012, when she proclaimed that they were married, all the way through 2017, when she availed herself of resources within the law, where she applied for a protective order because she felt that she was in danger. She applied for a protective order, and after 7 years of 100% financial reliance on Mr. McPherson, she files a protective order and all of the financial support stops. That is precisely what the legislature was trying to avoid. She now, in her direct testimony, is now reliant on food stamps, and she's relying on Medicaid. And he's earning over $300,000 a year. When the legislature originally was talking about this statute, they talked about welfare fraud. They talked about situations where parties were not claiming that they were married. One was the breadwinner and could support the family, but because they were not married, they would take advantage of the public benefits. And that's really what we have here, though conversely. She's forced to take advantage of public benefits because of the situation that he put her in. He completely abandoned her, which is what Senator Reese talked about on the floor of the Senate, that they do not want situations where a party is abandoned. And here I will take it one step further, abandoned and then basically completely reliant on government assistance, on taxpayer money to support them when for 7 years after supporting a career, mind you, in 2012 he was earning less than $70,000. 2017 he's earning over $300,000. They were living a very nice lifestyle. They were able to move to Mexico, to Cabo San Lucas, and they did that for her health. He was able to support her medical care because she needed some alternative medical treatment. He supported all of that, and they had this lifestyle based on his income that she helped grow. And as a result of that, because she filed for protective order, then that stopped. And now she's relying on aid. And so I do want the court to look, when I ask to look at the totality of the circumstances, we are asking the court to look at all of the circumstances in this case. And that is, this should not happen to a relationship, and this is what the legislature intended not to have happen. Does the court have any questions of me?
It appears not.
Thank
Thank
you.
you, Ms. Thompson. Thank you, Mr. Miles, for your arguments today. We will take this matter under advisement and render a written decision as soon as we can. And let me just compliment you, Ms. Thompson, on your first appearance in a Utah appellate court. You did well also, Mr. Miles. Thank you. And with that, we'll be in recess.